the first to know Nsem-Pii TV.
Be the first to know ampa Nsem-Pii TVs. Ebusia, memamo akwaba. Nsem-Pii for and Nsem-Pii for Ebekaya. On 24 January 2024, Ghana nyina edane ebutui. Na nyina fa news bia ebabeto dwa say penifo edubi abomutrim pose ombetu den time abaya no mote so egu former president Akufo-Addo ene ne NPP aban egu na penifo we kra mu baako efemu ehwene nkwa Dr. Frederick Mapam na me emfa ne kra ensie na ya ebeka no na emunsia asojafo ana even kra Dr. ACP Benjamin Abozo eka hu bi na abra omkopie mu court no nhwemu elebetu dwa say ACP Dr. Benjamin Abozo de ne hu so onfa ne hundi na emu 8 na ebeka no court no esa eja emu mienu ema omfa omudi na emu nsia na ebeka na nipa ba akwa no ye the third accused person ano ene hu ebon nsemwe kra mu ana court enhwemu na videos any pictures evidence court room no na biada pefe say openi bright dela ofosu we ofosu openi ne picture ikwa na da screen so no na sa abrantie we ana videos and pictures evidence de copy mu court no ebeto obia say ono ana draw Ghana security installation nyina egu krata so say na me adum na den time president His Excellency the former president Akufo-Addo say timichi na ye de ne befa de na kopia ye de befa de na kopia no matu aban no egu abusua ono ene ne lawyers akopia mu court ene na ene omkopia mu court no court ne se den yenko na yenko tie
Tumika na yanko ama brako ampofo nchen na yese chansin bi apai tension apai ni nyina ne say yese convict bi no yese ya granting 2.5 million bail and also so serious conditions are eteye chire no enya asem keto akra bright Alan Debra ono no wasem na ye kan yankwa homa so na ama brako ampofo court hima ono na asemi obetimi achemu ye ede amaye ama akwa baba wudiem na ba ne sane yese tension asori nye tension ketwa ewo obi bail condition a ye de ama no hu.
Okay, yes, sir.
Yo, ama yetie wo then na obi bail condition say ho tension enye tension it was very high voltage tension eba ni saying
Procedural obekai say Nsem-Pii eni adunu na jinu aboso ne de to so adunu enai 24 January 2024 Ghana na edane butu nyina ense enipa mako edu emu ba akokra eto ananan won se do Dr. Frederick Mapam na me emfa ne kra ensi ema nkoka eman na ACP Dr. Benjamin Abozo eka ho bi na sojafo mako nsia eka ho na yebeka se oba baako ana okra kwala ketwa WO2 Esther Asan na Colonel Gameli Alan Bright Deborah Ofosu na empenifo yesusu se omo ye omadwen so betu abanyego NPP abaya sabre na mampe enkane mampe ni na do dango Akufo-Addo na tie dwom na bra court na kwa asetena nyina ewie ye no eno kan say ACP Dr. Benjamin Abozo de no so enti ompi nko ma ade a ene okoye na emu mako enwotwe na aka no ija emu mienu eka ho ma ebeka enipa ensia no emu ba kwa no di akotene pa ya branch ani efe no Alan Bright Deborah Ofosu wono ene yesusu se no ye onipa otoso ni ensakra ede kwa edu ebo no videos any audio evidence ye de ba court dem no chese sa branch bi ene yesusu se odro Ghana ye security installations aho ni nyina odro ediku krata so chese ti ku choma mpeni anka ha ne de ne be fa ha ne de ne be wura ye be ye ni se ye de ne be ye ni se a branch ye no na akode fiase etwa mu no January 24th ebeto se seme and I was filing a friend bill pending appeal. Also, the so-called appeal say, quite ready to say, and pass it, Annie, do baby who say omo ye yes omo ko dey yes omo ko na nyina ye sentence on to death omo dey nkwa dey na life sentence to death ankasa owo na na so omo ko e no wa file the friend bill pending appeal ene na 3 justices at one for me and son etina so it's say treason felony at one for me and son nyina ma kwan e man ne lawyer Owura Matthias the Gina court na Nsem-Pii say there was exceptional circumstances evidence prosecution in the by na ke bi o wa say court no ejitum or say court no take on fan with you so eno na attorney general so ye so che mu say da bi o ade na brante ne kan ko bi ani na so at mo for me ensa no e sori ko ba ye o adwen ko benku mi o mo che say o mo hwe nsem na ye de beto o manim tie ne yakeka na o mo jitum sa brante na say e man bi na court of appeal na okoye na appeal na no na bill aye dia man no hema meti bill na no yeti 800,000 na we 2.5 million Ghana cedis 2.5 million Ghana cedis any bill sam yes on say nipa bi enyina na nipa bi no e se bu ba ko e we japade a ne bo ne so 2.5 million e japade o se up a landed property. It's nipa bi na ese mu ba ko e we japade so 2.5 million court say ordinary stop list so ontimi tukwan enfi o mind na mu anko ba bia empo so bi tukwan ko mind for so na se Ghana ha ba bia ese so be court na mane no be kire bi ntia ese e ma ne kwan wa ko court say passport bi o bia no on fa me to court o e no achi ne e hu kura o mi se court say o ma ne boso no mako ensia appeal no court of appeal akwakoye no on fa nkrata ni nyina go court of appeal ni en start se bre boso ni ensia na so no nye ne court na hye ne ndia court na attorney general e wo mo kwan say oba na bill aye dia man no obeji bill ni fini nsema abrantie no e sign ko me na okasa abrantie ne na ono nkasa ba court wa o hwe na ene ne kokko ne bia be kan wa ye kama pa ye man ne bill ni wi o de ni tie pa na e kofi e ko nsawa mu baka the lawyer nso akire nsem for say o jide ma pasa abrantie be mi ti bill conditions na no na lawyer for e bi nso ka say da bi o I say the court na ye ne no omo bie kwan dia to ama nipa num na aka ne nso abosa kwan na afa so but on him obeka say early days yet enipa ensia ye sentence on for treason felony ene ba kwa ba high court abenya bill pending appeal yaman 2.5 million with 2 sureties want to be justified with landed property
ama yahunu foni bi akrachi bi sa atade fufuo na nanimu no na amanfo bi sasa asa yaye mistake wenye Papa J nkwada abrem photo na yede atoso ama kirem
Ayima we eyemfoni a enne abrante na Treas0n de ba court opie esi emu esi abonten no ena minyaye enti wu se court abonten so court na Treas0n de ba court orensa won say handcuff egunensa enye Papa J emotional brain enye nemrant brain Alan Debra ofusu wono ene yesusu say ono na court man say onko dey fiase ne nkwa ne nyina ene oba court enti if last year e beto se mere ena Rebecca say dia wasesa na say ne ho ayefe me de hu no meka say ne ho ayefe pa e no sere ye o ze ne kokko ni bia beka o ena o say me mpie ko ba bia ista ma say say e de hye ne de onko do bia enti e jasa enti e ya branch na ye ka so onko dey fiase osusu bi wu no ono eno no
mo ama brako ampofo na yekotie no plus with geography to paint no
repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment. then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Honorable
So,
Minority
let
Leader,
me finish.
with all
Chairman,
due respect.
You allowed the Minority Leader. I'm responding
I'm
to his
not asking
objection.
the Minority Leader to raise an issue. Order.
I am responding
Order.
I'm responding.
Honorable
Let me
Minority
respond.
Leader.
Let me respond.
Honorable Minority
Let me
Leader, hold
respond to
it.
him.
Honorable Minority Leader, hold it. May your microphone be off, Minority Leader.
Chairman, just a second. Bear with
Minority
me.
Leader,
Chairman.
let your microphone be off. Hear
Chairman.
me out.
Very well. I will hear you.
Yes,
and
I'm
then
supposed
continue my
to
argument.
play the fair game here.
If you make your point, we respond.
Honorable Minority Leader,
What is wrong?
please, just
I don't have to
observe
respond.
me.
The Fiamma Paul spoke.
Hear
for
what I
almost
will want
20
to
minutes.
say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been-
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee
So-
swiftly empaneled the court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. if that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
there is-
Chairman,
I have the floor. You've not called me.
Chairman, the rules.
You have not called
the
him.
rules.
Chairman, you
the
see,
rules.
Chairman,
the rules.
Chairman, he puts
the
on the
rules.
rest.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. So when you just come in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I've stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the Majority Leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay,
Not
no
for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read, in extenso, your motion. So anything that relates to your motion would not be entertained before this particular committee. Because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.